I'm attorney Phil Jusino, and this is WLINY's Finding Common Ground here on Altice. My co-host for this evening is Dr. Carlos Rivera. Dr. Carlos, welcome aboard.
Thank you. Thank you for having me.
Dr. Carlos went through the system. I guess you could say hell and back. I think he's still probably somewhat in hell with this whole system.
Yep.
Dr. Carlos also did a show on WLINY a while back called In the Best Interest of the Child. How long did you do that show?
Did it for about, I would say about 5 or 6 months. It was a great opportunity.
And you did a weekly show, correct?
3 times a week.
3 times a week?
Yeah.
Oh, 3 times a week. You did more radio than I did at the time.
For a short period of time.
Sure. Now, what I want to do tonight, I'm going to do 2 separate segments. The first segment will be with Dr. Carlos. The second segment will be about equitable distribution. I want to get right to it. Tell me a little bit about yourself, how you found yourself in this predicament, and what are some of the things you tried to do to get yourself out? I know you had the show, and you tried to, I guess, raise awareness of
Yes.
your plight and other people's plight, because I'm sure people came to you with their situation.
Sure, absolutely.
And also Gary Jacobs, you have done work with Gary with, what's the name of that organization again?
Americans for Legal Reform.
Right, with Carl Lancasara.
Yes.
In fact, they've both been guests on my show. I've been a guest on Gary's show. But tell me a little bit about yourself.
Well, I'm a pediatrician. I had a practice in Patchogue, New York. I went to medical school and residency in SUNY Stony Brook. I had a private practice for about 15 years in Patchogue, and I loved the practice. It was wonderful. Things were great. I was pretty much living my dream. And next thing, you know, things that happened is that I was in a marriage. I was with my my now ex-wife. We were together 22 years, and at the time married for 15. And things didn't work out with the marriage. And next thing I know, I found myself in my ex was sought divorce. Really
Here in Suffolk County.
Mm-hmm.
And you have kids?
Yes, I do have 4.
And at the time they were how old?
At the time, let's go back. Let's say
About 2011 when you finalized it?
Let's say 12, 9, 6, and 3.
Now, before the show, you and I were having a little chat, and you told me how much money you agreed to pay in the divorce agreement. And it was a shocking amount to me. Even if someone's doing very well, it was quite a bit of money in child support. I think you said it was at $6,000?
$6,000.
$3,000 for maintenance per month, and the extras. So there were times where you were paying about $15,000 a month?
Yeah, by the time you factored in home utilities, which there was no cap, and that was one of the things that happened to me. I went from having $500 electric bills a month to $900 all of a sudden when I was separated from my ex and she had the house.
Oh,
so when you start adding, life insurance, health insurance, utilities, extracurricular activities for the kids, we were looking at another $6,000 a month, bringing me to a grand total of averaging $15,000 a month in payouts.
That's a lot.
That is a lot. It turned out to be most of my salary, almost all of it.
Now, you said that when you signed the agreement, you kind of knew at that time, long term, you wouldn't have been able to support that.
Well, that's kind of a loaded question because everyone asks me, why did you sign this? And what had happened, unfortunately for me, is the stress of the divorce and the dissolution of marriage. I ended up having a nervous breakdown. And about 9 days after being released from the hospital from that hospitalization, I found myself at a conference table with my ex's attorney and my attorney looking into this agreement. So at the time, what I really thought was going to happen was that my ex, would try to keep the kids in the house to make as little change as possible in their lives, keep everything the best I could to introduce the least amount of tension, in their house and unfamiliarity. And my belief was that I would be able to sustain that for a while for the children, even though it would be hard. And then when my youngest was in kindergarten, my ex, who had a college degree, would go back into the workforce and we would start to work together to support children. That never took place.
Now, it was explained to you that to go back to court, you have to have a change, basically an unanticipated change in circumstances, right? And I don't know if the law was in place at the time where if your income went up by 15 or down by 15, I don't know if that was in place in 2011.
I'm not sure, actually.
I think it came after that. But, so you were looking at this as, I can do this short term.
I knew it was going to be hard, but my thought was that, okay, well, let's just figure this out and do the best we can to get through this. Not realizing the ramifications if I would not be able to keep up with it, nor my ex's intent of what she really had planned for me.
Now, at some point, you couldn't keep up. What happened then?
Well, I couldn't keep up. I had gone from being in a large practice to going into a solo practice, that was another transition at the same time. And I found myself that I couldn't sustain it. I'm starting a new practice. The overhead was difficult to begin with, on top of trying to cycle $15,000 a month towards my ex-wife and children. And it became, right from the get-go, my plane never got off the runway. There was no way I was going to clear the trees at the end of the runway. So I tried my hardest to try to meet the obligation. I was unable to, and it was within a short amount of time that my ex took me to court for contempt.
So she filed contempt. You didn't file for a downward at that time.
No, at that time, because I was still trying to figure out how I could just provide as much as I could for the children, thinking that she had an understanding of my true efforts. But honestly, she had different plans altogether.
And for our viewers, when someone finds themselves in a position where they cannot meet their child support obligation, they can file what they call a downward modification. And they have to show certain things, that their income went down through no fault of their own, and that they can't meet their child support obligation. But she beat you to the punch, so to speak.
Absolutely.
And she filed a violation. Now, a violation petition filed is done in family court, right?
Mm-hmm.
She filed in family court, which means you want that person punished. What happened to you in terms of punishment when she brought you to court?
Well, she brought me to court, and that was another. My case is pretty much an example of everything that could possibly go wrong, and it did. So when I found myself at the contempt trial, I had poor records, and I did a lot of things that most people would advise against, like giving cash,
Without a receipt?
not getting receipts.
Right.
I didn't want to antagonize the situation, so I did my best to provide and not antagonize, any kind of animosity between two of us, and that turned out to be a tragic mistake. So, despite the fact that I'd given over $494,000 in 4 years, in 4 years, I was still found in contempt, and the judgment was $160,000. And since I was unable to pay that, or the purge I was given, which was $80,000 purge, I ended up being incarcerated for 6 months for child support arrears.
Right. Now, it was a hearing. You had a
Yes.
hearing, and the support magistrate cannot sentence someone to jail. They can recommend it, and then you appeared before a judge.
Mm-hmm.
And that judge set the purge amount at $80,000, right?
Yes.
The purge amount is an amount that if you make, you don't go to jail. If you don't have the purge money, you go to jail, and that's what happened to you.
Does, and I have a criticism of that step, because what ended up happening was, to me, it almost seemed like a rubber stamp of the magistrate's opinion on that. So the magistrate made her opinion and forwarded to the judge at that time, and the judge almost took a cursory look through the paperwork and immediately went on the recommendations of a maximum penalty.
And hit you with, the purge was 50% of the overall amount that you owed at that time.
Yes.
Okay. Now, what did incarceration do to your financial situation?
It only made a bad situation worse, because at this point now there's no income coming in.
Right.
So my practice folded because it was already on the verge of bankruptcy. Actually, I should have filed for bankruptcy well before I actually did. So now the practice...
Which wouldn't have wiped out the child support.
It wouldn't have, but I was really...
Or maintenance.
No, but I was really trying hard to keep the practice alive, and really was financially, it was not viable. It really, there was no way I was going to make it. So by incarcerating me, it made everything worse, because now, if I wasn't able to meet this demand while employed, there was no way I was going to be able to provide for our children behind bars.
Right.
Mm-hmm.
I see. And it's almost like a debtor's prison.
It is a debtor's prison.
That, in a sense, that's really what it is.
And I, out of respect for you, and I love you dearly, but I really have tremendous disagreement with. There is no such thing as debtor's prison. I was incarcerated for my failure to comply with the court order to pay a certain amount. That's debt. So it truly is a debtor's prison, which should have been abolished 100 years ago, 150 years ago.
Now, I've been doing this about 29 years, and one of the things that a judge looks at, because I represent people, and fortunately a lot of my clients go to jail, but what happens is you go before a judge and you make your pitch, and you say to the judge, if you put my client in jail, he's going to lose his job, or he's not going to be able to dig his way out. Some of the judges, as you can imagine, are more sympathetic. Some judges, like you said, are rubber stamp. Others will say, all right, can you come up with $10,000 by next Tuesday? I've seen judges do that. I've also seen situations where my clients have said to me, I don't have the money. As soon as those handcuffs rattle, somehow the money comes from somewhere. Not all cases. That happens. And sometimes a judge doesn't always know what he or she has to do to loosen up the purse strings.
And I could see that most people are crying wolf, and the money turns up after. And for me, it was painfully obvious, after about a month, 2 months in jail, that I truly did not have the money. And that was, one of the things I was pleading on loans. Like, by that point, I had no assets. I had no 401k. I had no savings. My judge even asked me, "You don't even have a watch that you could sell and provide some money towards this judgment?" I said, "No, I have absolutely nothing."
Because you gave your wife, now your ex-wife, everything in terms of equitable distribution. Assets.
I left basically with my clothing and my vehicle, and that was it. As far as the contents of the home itself, every last thing was left for her and the children.
And again, that was a choice you made. You could have put up a fight, and you could have said, "These are the assets I want," but you chose you had a situation prior to the settlement, and you just wanted to get this thing done.
I did, and I really, truly did not want to have this acrimonious relationship. I was like, okay, it's hard enough to get through a divorce, and there's a lot of pain and a lot of emotions to work through. So it's like, okay, let me not make it worse by fighting over, the wagon wheel coffee table, like in that movie, right? And the truth was like, it didn't help. Even though the fact that I completely gave in to every one of her, I acquiesced to her demands, there was never enough. There was always more. And essentially, when your ex is out for blood, there's nothing you could do about it, really.
And for the record, just so people understand, I never represented your interest in any of these proceedings.
No.
For better or for worse, I didn't.
I kind of wish I did have you. I would have.
I didn't. I don't think I knew you back in 2011.
I might have survived.
Now, you also, you said you have 4 kids, and at the time they were younger. You worked out an arrangement at that time where you would have what you thought was appropriate parenting time at that time.
It never seemed fair to me from the beginning because it's a standard formula, Wednesdays, every other weekends, and alternating holidays.
Right.
But when you really think about that, that's very, very little time with your children. It really is. And that's one thing that I think kind of needs to change down the line. Amongst these things that I advocate for, a change in the parenting schedule will be one of the other things I think needs to be changed.
You know what? I think it has over the years, because when I first started practicing, it was very common for the father, let's say he was a non-custodial parent, to get what you just said. Alternate weekends, a dinner visit on Wednesday, alternate holidays, and sometime in the summer. That was pretty standard.
Yeah.
I've seen it evolve more over the years where fathers now are getting more, or the non-custodial parent is getting more, because some judges now are mindful of that. And they say, wait a minute, you're the father. You're half of the parental equation here. You should get more than maybe Wednesday for dinner. I see a lot more now, maybe a Tuesday night, overnight into Wednesday, because the father wants to spend a little more quality time. And if you get 6 to 8, that's just a dinner visit. Then you have to drop the child off.
Yeah, it's hard. And I think really what they should stress is that this did not happen in my case, was that this schedule is a suggestion. It doesn't mean it has to be strictly adhered to. And that parents should be encouraged to divide their time equally with the children. The children should have access to either parent freely, as opposed to the rigid Wednesday.
Now, all of my agreements contain "and any other times as agreed to between the parties." So you're right. The mother should say, "Look, it's only it's Wednesday, but however, you want to see Dad? Why don't you go see Dad?" Or Dad should be able to pick up the phone and say, "Can I see Junior tonight?"
Yeah.
And Mom should, whoa, it's not in the agreement.
Yeah, that's hard. Or I've experienced where the dinner agreement is on Wednesdays is 5:30 to 8:30. However, if my children are home from work or if during the summer and I want to get them earlier than 5:30, no. So 5:30 to 8:30, and that was that. So in all fairness, my ex has never enforced the 8:30 part of it, but the 5:30, yes.
Do you think there was an element of parental alienation in your particular case?
Without a doubt, yes.
Okay. Now, we talked about parental alienation in a nutshell is when, let's say, the custodial parent is not encouraging the kids to go with the father, or worse, where they're bad-mouthing the father, to saying negative things. That's bad. That's called parental alienation. And I've said it before, and I'm going to say it again. I don't think judges do enough to really put the custodial parent in his or her place when there's parental alienation.
Yeah, I think part of the problem, I agree with you, and I also think the part of the problem is that the dynamics of parental alienation are counterintuitive. So when you look, for somebody who's not trained, not saying a judge is not trained, but it would look like, the children are much, much closer to one parent than the other. Right. So clearly that other parent is a less fit parent. And the truth that happens is it's children bond with the aggressor. So they tend to want to please the parent that is pushing the disparity that much
Sure.
harder. So this is one thing I think that it needs to be looked at carefully, and there should be repercussions from it. And my experience in family court is anything of monetary concern, the courts seem to push kind of hard and enforce that. However, parenting time, you might get a slap,
I
a
think
minor
that-
reprimand, but nothing.
I think that's a fair assessment. What I say is this, and this is the reason, I think you'd probably agree with me, the reason why judges don't want to take that tougher stance is because every case, for the most part, has a law guardian. And the law guardian says, Johnny, who's, let's say, 15, and Sally, who's 10, they want to live with their mom. Then what do you do when you see parental alienation? Do you yank those kids from dad and give them to mom? That's one of the remedies, and I've seen that happen. But the judge, who's mindful of the parental alienation, and they see it, they're going to say, wait a minute, though, that's not what Johnny and Sally want. And then you have the attorney for the child, used to be called law guardian, saying, I have to make the recommendation that the kids stay with mom.
Wishes.
Right, they have to, because they're not 5 and 4. So you have a judge that says, look, I see the parental alienation, I'm not happy about it, but I don't want to hurt these kids. One of the remedies that I thought of is this. Why doesn't the judge hit that parent, whether it be the husband, the father or the mother, with attorney's fees? That might be an idea. So if you filed a petition for under the theory of parental alienation, and I'm the judge and I say to the mom, I see what you're doing is wrong. I don't want to hurt the kids, because the kids will go kicking and screaming if I say you're going to live with your dad tomorrow. But you know what? You're going to pay $5,000 in attorney's fees.
I think if there was some type of repercussion, I think that would go a long way in correcting the problem. One of the analogies that I heard that I really love is the bird on the wire analogy. If you have a bunch of birds on the wire and you throw a rock at one and maybe you hit it, I'm not advocating harming animals, but they all scatter. So I think if you take one person and make an example of that person, like, we are going to enforce this. If you do not comply with the parenting schedule, or if you interfere with the natural bonding of a child with the other parent, there will be a price to pay. And
there should be.
And there should be. And it may be monetary, maybe a warning, community service, whatever the infraction, it has to be set up. But I think that would cut things down quite a bit, and we would see a lot less alienation. And the other bigger part is that it's not just the alienation where a parent can't see the other child. It's actually damaging the children down the line. These kids are growing up with mental health issues, increased substance abuse, increased promiscuity, decreased performance in school. There's long-term effects to alienation. So these are things I think the court really
And I
needs
think
to
there's also
address.
going to be an element of guilt, because years later they're going to say, they're a 15-year-old kid saying, I wish I had a better relationship with my dad. And they might take on some of that blame.
Oh, absolutely. There's quite a bit of emotional harm that comes to them, and I think that if you mislead a child, for years and years, and eventually they'll come to understand, like, I was misled,
Right.
and there's more to it. Like, mom wasn't quite the person that dad described, and vice versa.
A lot of years are lost in the process.
Yeah, and you'll never get that back. So it's one of the most painful experiences I have ever experienced is alienation, and I've lost both of my parents, one before medical school, one while I was in medical school. Pales in comparison to alienation.
I can
Without a
imagine.
doubt.
What are some of the things you think that family court could do better? I know we had a little conversation about that a little while ago, and I want you to be honest and say what you think. I really mean that.
It's interesting to speak to you because I've admiration for you as a person and an attorney, and I think that you represent the attorneys that are actually doing their job. I think that a lot of attorneys, sadly, are seduced by the money. And then if you keep people fighting, there's money to be made, and we kind of some attorneys lose track of the emotional harm that's happening to these people. And there's so many things that I see with court because of my activism and the show that I had on WLINY, and then I'm actually seeing a higher percentage of people who are alienated from their children or had really, really poor outcomes in courts. So I really believe that there should be more oversight in the courts. That some of the judges' decisions, behavior within the court should really be monitored more closely, and there should be a stricter adherence to constitutional rights, which I've seen on many occasions violated. And I find that that's very, very troublesome. So, a start for me would be some type of true oversight for the people involved. I believe in cameras in courts. You brought up some interesting points about anonymity for parties involved, confidentiality. Right. But I really think that there has to be more built-in fail-safes for the system.
See, I could see cameras in the courtroom more with a criminal case
than
a family court. But also, everything that's being said in that courtroom, as you know, is being taken down. So there, at the very least, there's a transcript of that.
I see what you're saying. I think that I have some issues with transcripts, and I don't, you might believe they fall under conspiracy theories. But I really think if you're not going to use names, instead assign pseudonyms or numbers. Person.
But what would you do
843.
with the footage? You have a camera in the courtroom. Does it go on TV? Is it there for someone to order if they need to do that?
Kind of like I believe it should be available.
Similar to a
like
transcript.
Like, okay, this is what actually took place. And I think that if you have an issue that's going to appeal, when you look at a transcript, you can't really get the nuances of how it took place. In certain cases, I've witnessed judges who were extremely aggressive against one of the individuals, and that would never translate in a transcript.
No.
However, if you get to see that behavior either on audio tape or some type of videotapes, like, okay, well, this is a different story, and why is this judge's behavior this way?
Well, look, even though I guess I would have to say I come down against cameras, you have a good point, because people that are being taped, not just a transcript, the attorneys are going to be better prepared. You know that, because no one wants to look like a fool.
Sure.
The judges are not going to be eye-rolling. They're not going to be getting aggressive, as sometimes they do. And I've seen things not be in a transcript that were said because, oh, look, off the record. You know how many times I've heard that,
sure.
off the record? We don't need to put on the record, or something said, and the court reporter, I guess, did a favor to the judge and didn't put something in there that really should have been in there. Everything that's said should be taken down.
Absolutely.
And if you have a video of it, but again, I don't know if I'm ready for that yet. But I think there's valid points on both sides.
Yeah, I'm not saying to put it on national TV each and every court case, but I think it should be available for the person who has an issue, who's looking to file a complaint or is looking to go for an appeal. Then perhaps this information should be readily available, as opposed to just the transcript.
It would have to be another level of information an appellate court could look at, because right now all they have is the transcript, just words on a page.
Yeah.
And if they had a video, maybe they would say, wait a minute, this judge seems to be so one-sided, and you can't always pick that up with what's being said.
Yeah, one-sided or just aggressive in general. I think that my feeling, and from my experience court watching, is the court takes on the personality of the judge on the bench, and you may have judges that are a little bit stricter, firm, or have set in their beliefs, and you can't help but notice that there's a certain feel to that court, and it kind of goes along with the judge's personality. And that's just my observations as a court watcher that I've seen.
Sure.
Here.
And I know this firsthand because I'm in the courts. There are a lot of good judges, but there are also judges that I feel let sometimes their opinions get in the way, or their personalities, and things, people clash. And that's, look, a judge should be fair and impartial, hear the evidence, and make a ruling. It shouldn't start out where you can tell that the judge is against one party or the other. And I see that often. And I also see where judges sometimes make attorneys look bad, which I don't like to see, where let them try their case. Right? If you're going to rule, I always say, look, judge, you want to rule against me? Be my guest. Do what you have to do. But don't make me look bad. Or don't make some other attorney look bad. And what's the point? That's why I'm saying a judge that respects the litigants, that respects the attorneys, that respects the process, and also follows the law, those are the best kinds of judges. But not all judges are like that.
It's hard because as you're saying these things, like, people are human. People make mistakes. People are going to have a bad day. But I think that there's such a high standard and such a level of respect that goes with that people have to be worthy of that respect. As a pediatrician or a physician, I truly believe in high standards and that, utmost concern for patient care and well-being. And, if I fail to meet my duties, then there should be some type of oversight for that. Either there was an issue of malpractice or things could have been done better. And I believe that should exist for, judges as well. Not an easy position, but at the same time, this is why they're there. These people have, high esteemed positions, and they should meet the responsibilities of that.
A
lot of power, but a lot of responsibility goes with that. So, meet the responsibilities.
And there should be accountability. You had mentioned something to me that I'm not really familiar with. You said 4D incentives, or Title 4D incentives. Explain that.
I was interesting because I was watching your body language as I was talking about it, and I wasn't sure if you disagree with me. But as part of the Social Security and Welfare Act, there is in the United States, in order to collect on monies that were distributed through the Social Security funds, were now that act was designed to collect the money that was doled out in Social Security welfare recipients. And what ends up happening is there's a federal incentive to collect that money back. So if you have somebody who's now put in child support arrears, the federal government now will subsidize the state. I have not come across an actual listing of the amounts, but I've heard amounts between 75 cents or $7 on the dollar of federal money for the state to collect arrears. So now what ends up happening is in the case of child support enforcement can charge anywhere between 9% and 14% interest, depending on what state you're in. New York is 9. New York is 9. Now, if you take that interest and then combine it with the federal incentives, so let's say that somebody gets $7 on the dollar, you take a person like me who's now in $400,000 worth of child support arrears, $7 on the dollar, now you make that $2.8 million to the New York State Child Support Enforcement System. So there's an incentive now to put people to keep people in debt that they'll never be able to get out of. There's no way that I'm going to get out of this debt at 9% interest. There's just no way. So I'm an indentured servant for the rest of my life.
But do you think that the support magistrates, when they make decisions, that they're mindful of that?
I think so. There's budgets. This will go towards the state budget. And there was, I believe it was in Illinois, there was somebody on one of these panels, and it was an attorney, and somebody was making the argument against abolishing the Title 4D incentives, and this person said on camera that would destroy the state's budget because that's where most of this money is coming from.
Wow.
So I mean that was quite a mistake error on that person's part. But what it did was it actually validated these claims that people make about the Title 4D incentives.
Wow. See, I wasn't familiar with that. I'll be honest with you.
Yeah. I mean, it's something to
How did you find out about it?
Well, once you get sucked into the machine, then you start learning about all these little cogs and pieces in it. But as people that advocate, for reforming the family court system, that's a very, very common knowledge amongst that group of people.
Okay, that wasn't something I was aware of.
Mm-hmm.
And a couple more topics quickly.
Mm-hmm.
What other things do you think the family court could do to improve on itself?
It's kind of hard because, again, I'm in a subset of people who have been harmed quite deeply by family court. I think that there could be a stronger adherence to constitutional rights. I've seen people have constitutional rights violated on a daily basis in family court. That'd be one thing. I think that there's an overloaded system, so there needs to really be some type of mechanism to have enough people available to really address the problems. I could see how the attorneys, the 18B attorneys, are overworked. The judges may have a high load, so that we have
sometimes
to
they have
volume.
8, 9, 10 cases on a day, and it's hard for them to get around and cover all those cases.
It's not easy with everyone has these polarized versions of the same story. So how do you decipher that? I mean, it's a very, very difficult position for attorneys to be in and judges to be in. I get it, but at the same time, the system is really it's a woeful need of reform.
Okay. And how do you think, who do you task with that responsibility? Do you think, like you said, oversight of the judges? Well, there's a chief judge in family court, and that judge could maybe do more.
I honestly put the blame on the voters.
But they don't always know who they're voting for.
But they need to be more active. I think that people don't exercise their voting right. They don't look at who's on the ballot for which judge is going to be appointed. And people need to really, if you want to change, you can't just ask for it. We really need to go about the process that's in place. Like speak to your representatives, speak to Congress people, and I think that's where it's going to start.
But with the cross endorsements, it's very tough sometimes because if you're running for a judgeship and you got the Republican and conservative, or Democrat and conservative, or Democrat, conservative, and Republican, you're in.
It is interesting because when I vote, I look at those cross endorsements. It's like, this isn't a vote. This is actually an announcement. Because no matter what, these are the people who are going to end up in there because they're represented by every party. So that is a big problem. And I think that we really need to look at these cross endorsements and see these are, honestly, they're legitimate.
Right. See, I think a good way to go about it, too, would be electing judges. Now, I know the people that are running. So I have an advantage. Attorneys that are in the system have an advantage over a situation where you don't. Like you might go in there, you could do your homework. Where'd they go to law school? How many years have they practiced? Voters should vote for people that are qualified, that have practiced in that particular court. I've walked into district court, I've walked into family court in certain places, and you see people up there that are judges that I've never seen before. And I've been doing this 29 years, so what does that tell me? There's somebody that might have been a great bankruptcy attorney or that might have been a good litigator in some other field, and here they are making decisions on cases where they don't have experience.
You touched upon another concern of mine, in that you have 29 years of experience, and that's invaluable. I mean, you've seen things by experience, you've been there day to day. But when you have a new attorney coming out of law school, there's no formalized training in family medicine. Like for me, to practice medicine, I had to complete my medical degree, then do a residency, specialized training, then pass boards and get certified, and then I was able to practice. Attorneys, to my knowledge, there's no such process for that. So you can have a person who comes out and was practicing personal injury, now finds himself in family law. How much do they really need? How much do they know? So you really need to address that.
Yeah. Listen, I want to thank you for coming in. I'm going to bring you back on another show because we touch on a lot of topics and we're limited with our time. But I really want to thank you for coming in.
Thank you very much. It was a pleasure.
I'd love to get you back on the air in the best interest of the child.
Well,
Maybe
I would love to be back.
We'll talk about that. You're back with Finding Common Ground here on Altice. I'm attorney Phil Jusino. I want to thank Dr. Carlos Rivera for being my guest on our last segment. What I want to do for the next 20 minutes or so is talk about equitable distribution. Now, what does that mean? In New York State, when you're going through a divorce, the court is tasked with the job of dividing up the assets. There could be a house, there could be vehicles, there could be pensions, 401ks, you name it. Anything that someone owns is fair game to be distributed in a divorce action if it is deemed a marital asset. And we're going to get into that right now. Now, what does equitable distribution mean? It means divvying up assets in a way deemed fair to both sides. It doesn't mean necessarily 50-50, although it often falls that way. Often, when a case comes to court and the judge says, what do the parties have? And let's say they own a house and there's $500,000 of equity, where it's clearly a marital asset. They bought it together, the down payment was equal. The court will generally say each party gets $250,000. That's the practical way things are done here in New York. I can't speak for other jurisdictions, but here in New York, equitable distribution doesn't mean 50-50, but most of the time it is. Now, what is a court supposed to consider when determining equitable distribution? And just to go back a second, New York is equitable distribution. Not all states are. Many Western states like California are what they call community property. I personally think equitable distribution is the fairest way to do it. For instance, if someone gets married and they have assets prior to the marriage, those assets are usually deemed separate property. There are exceptions, and the court doesn't divvy up those assets. In other states, like with community property, it's not always that fair. So what does the court consider? The length of the marriage. The longer the parties are married, the more likely it is that it's going to be a 50-50 proposition. If the parties are married 1 year, not as much. Each party's income and assets. So let's say the husband is making $500,000 a year and the wife makes $25,000. The court could say, all right, you know what, I'm going to give her the house. I'm going to give her more of the house to make things a little more fair, especially in a long duration marriage. Again, not so much in a short duration marriage. The age and health of the parties. Let's say one party is very healthy and has a long career ahead of them, and one party doesn't. The court can divvy up the assets differently. They look at tax consequences. What are the tax consequences? For instance, if one party gets a basket of assets while the other party gets another basket of assets, one basket might have tax consequences that gives that party an advantage. So the court can divvy up things and say, you know what, instead of giving you $500,000 of assets where there's a big negative tax consequence and the other side's getting $500,000 of assets where there's no tax consequence, the court might say that's not fair. Right? So maybe the one that's getting hit with a big tax consequence might get a bigger piece of the pie. They look at what each party is to receive in the settlement. They look at the likely financial circumstances of the parties. Again, is somebody going to go on to make a lot of money whereas one party doesn't have that opportunity. Whether a party has transferred assets in the marriage or in contemplation of the divorce, like giving assets to a family member or to a friend. A court can take that into consideration and say, not so fast. You can't give that Mercedes to your cousin Charlie. That's a marital asset, that's coming back in, or the value anyway. Because if you give up an asset like that, you might not be able to get it back. But the court can say, that car was worth $50,000, the other party should have got $25,000. So write a check. All right. Has the separate asset been commingled? So for instance, let's say I inherit $1 million. That money that I just received is separate property. If I keep it separate, my spouse cannot get any part of that inheritance. However, if I commingle it, let's say I take the $1 million and I stick it into an account, not just for a matter of convenience, where the court could say it hasn't been commingled, but because I want my spouse to be able to share in that $1 million. And then we use it. She gets to use it. I get to use it. We buy things with it. She buys things with it. The court can say that that marital or that asset has been commingled, and where it started out as separate property, now it's marital. Whether an asset has been transmuted, what does that mean? If I get married and I come into the marriage with a house, clearly in my name, clearly my own separate property. If I put my wife's name on the deed, I transmute that asset to a marital asset. It gets a little more complicated than that, but suffice it to say that my spouse then would share in some proportion with that asset that has been transmuted, and other factors that a court deems just and proper. Also, you could look at a situation where there's been wasteful dissipation, which we'll get to in a little bit. Now, what is a marital asset? Generally speaking, an asset is marital if it came about during the marriage. Husband and wife get married, they buy a house together, they buy cars, they contribute to retirement accounts. Those are all marital assets. And again, there are exceptions to the rule. But suffice it to say, a marital asset is an asset that the parties got together during the marriage. What is separate property? Separate property is generally defined as property that you own prior to the marriage. So if I come into the marriage with my own house, again, with few exceptions, that house is my separate property. Now, if my spouse used their money, or even marital monies, to put a new roof on the house, to improve on it, they might be entitled to a credit. But for the most part, that's still my separate property claim. Another example would be, let's say I have $1 million inheritance. I'm a single guy. Now I get married. And while I'm married, I want to buy a piece of property. So I tap into my $1 million account. And I use that $1 million and I take $200,000 out of it and I buy a piece of property or any asset. I can trace it back to a separate property account. So therefore it's separate property, even though it was purchased during the marriage. So generally there's a presumption an asset purchased during the marriage is marital, but it's rebuttable. So if I'm going through a divorce, I'm going to say to my attorney, I bought that piece of property during the marriage, but I used separate property monies. Generally, that will be deemed a separate property asset. Transmutation, I mentioned that a little while ago. That's where I put my new spouse's name on a particular asset. It transmutes it. Now, what's interesting is, I'll give you an example. Let's say I get married today, and I have a house with $500,000. And I say, you know what, I'm going to put my wife's name on the house. So I do a deed transfer and I put her name on the house. So now the house is in my name and my spouse's name. Let's say 5 years down the road, I file for divorce, she files for divorce. It doesn't matter who files, but we're now embroiled in a divorce action. The house is now worth $750,000. What happens? Do you say 750 divided by 2? No. If I want to save a separate property claim, what I have to do is get proof that the house had a value of $500,000 at the time of the marriage. So that would be my separate property claim. My spouse would share in the appreciation. So if it went up $250,000, she would get $125,000. Now, I didn't factor in any mortgages or anything like that. If there are mortgages, you go by what the equity is. Okay? Here, I assume just pure equity, no mortgage. But that's an example of transmutation. I had a case one time where someone came to me and the prior attorney only got the appraisal for what the house was worth now at the time of right before the trial. And I made him go out and I helped him, and we got another appraisal showing what his separate property claim was. And it was a house, a high-priced house in Dix Hills, and I saved my client $400,000. Because if you looked at it the other way, even if at trial he testified, I have a separate property claim. If he couldn't prove the amount, the judge could ignore that and say the burden is on you, the one who's saying it's separate property. Because again, it was purchased during the marriage. Or it became marital property during the marriage by putting my wife's name on it. The burden is on the person claiming the separate property claim. Now let's talk a little bit about wasteful dissipation. Now, what is wasteful dissipation? Wasteful dissipation is when one party wastes a marital asset. If they waste a separate property asset, the court's not going to care. So if you had $1 million in an account that was clearly an inheritance, and you blew that money on gambling, you gave it away, the court's going to say, I don't care. That was your separate property. But what if it's marital assets? So a party gets married, and let's say they save $100,000 during the life of the marriage. And during the marriage, the husband takes that money and he wastes it. Let's say he gambles it away, or he invests in something that is purely speculative, not that he buys a legitimate stock that goes under, purely speculative. Or he has a girlfriend and he uses that money to help her out in some way, buy her a ring, buy her a piece of property, give her money outright. It doesn't have to be a girlfriend. It could be he gives it to his mother, let's say. That could be deemed a wasteful dissipation of a marital asset. What happens? The court has to determine what the amount of the waste was. So in the example where he took that $100,000 and he gambled it away, now the account has nothing in it. What does that mean? The court can order that husband to pay the wife $50,000. Now the money might be gone, assuming it's gone, it was wasted. The wife could get a $50,000 claim against the husband from some source. It could be from a retirement account. It could be when they sell their house and each would normally get $250,000 each. The husband has to pay from his share to the wife $50,000 in that example to make the wife whole. And wasteful dissipation has to be proven. The burden of proof is on the one who's claiming that the other party wasted an asset. So that's wasteful dissipation. That comes up more than you think. Now, the court can also look at maintenance. In other words, if a party's getting significant maintenance, they can make a determination on the asset using that as a factor. And again, equitable distribution is not always a mathematical computation. The courts look at those factors that I talked about. For the most part, as a practical matter, courts generally do 50-50. It's just easier that way. So I've seen cases where the husband's making $400,000 a year, the wife's making $25,000 a year. There's a house worth $500,000, and the court says, what are we doing here? It's $250,000 each, because they look at it as it is clearly a marital asset. Now, with regard to equitable distribution, there are other considerations that the court can take into account. Now, I said other factors. The court can look at how a party has conducted themselves. Remember I said you wastefully dissipate an asset, but it might not be as clear as a wasteful dissipation of an asset. It could be that a party didn't pay the mortgage and had the ability to do so. I've seen cases like that where the person lost their job, but it was their fault. And they say, well, I can't pay the mortgage. Now, what happens when you don't pay the mortgage? You lose that house. The house goes into foreclosure. Or if you don't pay the taxes, that house is lost. The court can take that into consideration and say, that house went under, so therefore I'm going to blame the person who should have been paying the mortgage all along. Now, in addition to equitable distribution, the courts also, and then we're going to go into an entirely different topic, the courts divide assets, but they also have to come up with child support, if there are kids involved, and spousal maintenance. Now, in a divorce action, the court has to look at a lot of different issues. In family court, it's limited. So in family court, let's say a woman is married and she wants to get child support and maintenance from her husband. She doesn't have to go for a divorce. She can file an action in family court. Family court can't give her a divorce, but she might say, you know what, I don't care. I don't want a divorce. I need child support. I need spousal maintenance. That can be done in family court. You can't get a divorce in family court, and the person who's not married can't seek spousal maintenance. They can only seek child support. And in New York State, child support is 17% one child, 25% for two, 29% for three, and so on. So what they first have to do is determine the income of the parties, but it's really the one who's paying. So they determine his income. There's a cap that can be used. But for the most part, if a guy's making, let's say, $140,000, they will determine his child support based on his gross adjusted income. Gross adjusted income would be his gross income just minus FICA. They take out 0.0765. They don't take out if he's contributing to a 401k. They don't take out his federal taxes or state taxes for that matter. Now, when you have the interplay of spousal maintenance, there is a formula that the courts use. And in fact, I have an app. If I had my phone in front of me, I could plug in, husband makes 100, wife makes 50, 2 kids, this is what it is. There's a formula that's involved. The app just makes it easier. And for the most part, courts follow that formula. They can deviate, just like they can deviate with equitable distribution. But for the most part, courts determine child support and maintenance based on income. And then in addition to child support and maintenance, there's things called add-ons. So the husband could have to pay $500 a month child support, $250 a month maintenance, but also a percentage of what they call the extras or the add-ons. What are add-ons? Medical insurance, uncovered, unreimbursed medical expenses. Could be extracurricular activities. So if the child is in Little League, it shouldn't be fair that the custodial parent has to pay all of it, because child support is food, clothing, shelter. That's it. Food, clothing, shelter. The extras are things that the court will impose on the parties, usually in a pro rata basis. Pro rata would be if the husband's making $100,000 and the wife's making $50,000, it's 2/3, 1/3. So when a bill comes in, the husband's going to pay 67% of a $100 bill, and the wife is going to pay roughly 33% or $33 of that bill. Now I want to jump back because I'd forgotten to touch on this. When I said equitable distribution, I talked about assets such as a house, such as bank accounts. One thing I forgot, which I wanted to touch on when I saw it in my notes, is retirement accounts. Pensions, 401ks, things like that. That is distributed by the court. So let's use a 401k. It's a little easier with the numbers. Let's say a guy is getting divorced and he has a 401k worth $100,000. Does the wife get half of that? I didn't give you enough information to make that determination. We have to find out when he started contributing to that account. So let's say a couple got married in the year 2000. The husband becomes a cop in 2005, and they get divorced in 2015. She's entitled to half of that account, what they call the marital portion. In that example, the marital portion is the life of the divorce until the divorce was filed. So if he filed in 2015, 5 to 15. Even if the divorce dragged on for 2 years, it's still 2005 to 2015. What if he became a cop in 1990 got married in 2000. The company doing what they call a qualified domestic relations order. It's an order that a court signs to order a pension fund or a 401k fund to figure out how much the wife would be entitled to. So you have to factor out 1990 to 2000. So she would get half of 2000 in my example to 2015. He gets credit for the separate property claim. So the company would have to determine what's the separate property claim and what's not. That's how they do it. And they can look at it in a number of ways. One is you can get a statement to say when they got married it was $40,000, so that $40,000 is his, but you have to add to that because that $40,000 would have grown a little bit. So maybe $45,000 is the separate property claim. What I would suggest you do is when you're going through such a system, you do your homework, but you also hire an attorney that knows what he or she is doing. Because what I talked about tonight gave you a bit of information, but there's a lot more to know. There's a lot of considerations that have to be taken into account. And one of them is, what is the marital estate consist of? So you could talk about the law all day until the court knows what the marital estate consists of. Is that house part of the marital estate? Is that account part of the marital estate? If not, it doesn't get factored in. If it does, it does. I want to thank you for watching the show. We do this show every Saturday at 10 a.m. in the morning. For you insomniacs, we do this show at 1 a.m. on Thursdays. I also do a live show on Fridays at 8 p.m., which has a little more of a political flavor. I think you'd enjoy that. That's on YouTube and Facebook Live. So what you could do if you want more information, you can go to my website, jusinolaw.com, has a wealth of information. You can also look at other resources. I wrote a book called Divorce: A Practical Guide. That's a resource. There are other resources. It's amazing what you can encounter on Google, but again, get an expert's opinion because you want to make sure that you're protected. Thanks for watching. Take care.